That's a good question. Let me repeat that for those that are on the webinar. Is there a retention policy that should be set up for each local board? The answer is yes. You know, you should keep certain files for a period of time. Do we designate how long that should be? Not necessarily, but you should check with the state records and see how long they keep particular retirement paperwork. But yes, there should always be a retention policy. I would keep all of the retirement paperwork, all the active member, new member hire stuff, you know, especially disabilities, you know, things like that in the files. You know, we have some that keep it for so many years, some discard it after a period of time, but it's always good to keep those files on record, yes. Can a person who's working for ASRS transfer their time into public safety? Absolutely, yes. That person would terminate their position at ASRS, contact our office, our active members group, and see what that transfer of years of service would bring to that member. It's not always a one-to-one transfer. It may be 2 years at ASRS for 1 year at public safety. It just depends on how many years he has, and that goes into a calculation. But yes, you can always transfer from system to system in that situation. Good question. Somebody who's been working for public safety for many years, can they leave that money on account? Yes, but they've also been elected to an elected position. They have to then transfer their public safety time into elected, but the elected official plan is actually closed now for new hires, so it makes it a little tenuous. So they would have to move into the elected officials plan. They cannot stay in public safety.
Now, is that something that would be up to me to do, or is that something he has to handle?
The employee, whoever got hired, is actually done working for public safety because he's not in a covered position.
Right.
He would have to go into the new elected official plan, which is kind of like a DC plan, defined contribution plan. Okay. We have a few more questions here. Regarding pre-existing conditions, some of the medical conditions are not employment related. Do they need to be noted? Yes, in most situations, all pre-existing conditions should be noted, especially if they want perhaps a knee injury for a retirement later on a disability. You'd want to make sure it's notated in the file so you have record that the person has actually had a previous condition. Acne, I'm not quite sure. Is that important? You want to take a...
This is Robert. I just wanted to kind of follow up on that one. I think it's what local boards need to be aware of when they're looking at pre-employment physicals and determining pre-existing conditions is you have to look at it from the perspective of the duties of the role. What is it that this police officer, firefighter, corrections officers, what are their essential functions? And is the condition that was notated from the physician, is that something that could come into play in the future? Just because it may not be directly employment related does not mean that it couldn't come into effect later on. For instance, you have an individual who broke their right arm, 3 years ago, and it's their dominant arm. It's their shooting arm. Is that something that in the future, if they're in some sort of incident with someone, would that come into play? What you're basically doing during a pre-existing condition notification is just letting the individual know that condition may come into play in the future for a disability. It may preclude them. It may not necessarily, but it could. And you just want to putting them on notice that in the future, if you do have that instance where you hurt your dominant arm that was once broken, if they go through their IME process when they're applying for a disability, if that's what they're going to do, the doctor may say, well, had that condition not been in place, this person could have rehabilitated and gone back to work. Well, if that's the case, then yeah, you're going to be precluded from getting a disability. But if the physician said, well, regardless of whether or not that a broken arm was in place, this injury was so severe that they still are never going to be able to do this job, then even if you did put them on notice of this pre-existing condition, you may have to take action to say, okay, we're going to approve this disability because the physician is saying, regardless of this pre-existing condition, they still would not be able to rehabilitate. So that's what you need. There's no hardened rule on these particular conditions. You must always notate. You have to look at it on a case-by-case basis, and that's why it's really important that local boards really understand the roles of these positions. So hopefully that answers your question.
it's always good to also to realize that in a situation like this too, that if it's notated, the member knows about it. You've notified him by a letter. Hopefully, you've sent them a certified document that say we know about this, and it kind of protects the employer side of things as well, so they can't apply for that disability later for that particular situation. The next question is, how closely tied are your board secretaries and your payroll staff for small areas? I would say they're very closely tied. Sometimes the employer who's paying the payroll is also the local board secretary. They're also the human resource director. They're also, how many titles do you have? Several, okay. So yes, in smaller communities, they are sometimes the same individual, and it puts a lot of burden or pressure on the local board secretaries to wearing 2 or 3 different hats. They may be an administrative assistant to the chief. They may be a lot of different things, but we really rely on 260 local board secretaries to function and discuss things with our office, and that's what we're here to do, is to help you out with those questions that you have. Okay. How does HIPAA affect what we can know about our employees' pre-existing condition? Robert, do you want to take that one?
Sure, I'll take that one. Well, with this particular question, I would always refer local boards to always speak to their legal counsel to ensure compliance. But what I can tell you from a high standpoint with regards to HIPAA is HIPAA deals with whether or not an employer or an entity is a covered entity under HIPAA. And more than likely, this particular situation, being local boards and getting medical information, is not any type of HIPAA covered entity, because you are receiving medical information directly from the members. So they're the ones who are giving you this medical information. So there is no real HIPAA violations for utilizing this information or discussing this information. One thing that you do need to be cognizant of is part of the application process. There is a waiver that the member does sign off on the application that basically dictates that the local board can discuss these medical conditions in a public open meeting. What a local board may be more cognizant of or may want to be more aware of is dealing with records that may not necessarily be public records, and medical records sometimes are not considered public records. So if a member did not sign off on that waiver, there may be a point in which the local board has to go into an executive session to discuss the medical records. But outside of that, there's no HIPAA issues with respect to the medical information that you're receiving for disability determination processes. But again, like I always state, you still want to speak to your legal counsel to ensure that there are no other issues, because I am no lawyer.
On that, if we're in a local board meeting and we come with, like, right now we're hiring a lot of people, so we'll have 10 deputies being hired, and 3 of them have pre-existing conditions. Now, if the local board wants to know what those conditions are, is that something we can discuss, or is that what you were talking about going into the executive session?
Yeah, you'd want to go into executive session in that situation.
Okay.
What on the minutes of the meeting we need to see reflection of is the person's name, and you just have to put pre-existing
Right.
condition. You don't have to give, he hurt his foot, he hurt his knee, whatever the condition is. You just need to notate it in the minutes of the meeting and put them on notice through a letter.
I guess my question is if one of the members of the local board asks why I put it being pre-existing, can I tell them that because I was told that I can't?
Normally you wouldn't need to. Why
Right,
would the board
okay,
member
so
need to know?
I haven't had that.
Yeah.
That
Do you see what I'm saying?
question yet, but
Why
just
would the
in
board
case.
member need to know what the condition was?
I mean, I agree, but
It's
never
between the
know.
employer and the person being hired.
Right.
Okay.
Right.
I mean, if the guy wants to go into executive session and it's agendized to do that and discuss it, that would be his choice, but I don't know why he'd want to do that.
It's just one of those things, just in case, and I'll have the answer instead
Yeah.
of
Yeah.
going, I don't know.
Yeah, does that make sense?
Yes.
Yeah, okay.
Thank you.
So if the department is looking at an individual to hire who has a pre-existing condition that could result in a medical retirement, does the local board vote to accept the member as a member of PSPRS, and can the local board make that decision?
I think I'll go ahead and take that question. When it comes to hiring the local board has no hiring decision. That's an employer level decision whether or not they're going to hire an individual. So if the employer says that this person qualifies for the position that they're hiring them into, then they're hiring them into it. What the local board is only doing is determining whether that position is a qualified position for public safety. Meaning, is it a full-time certified peace officer or is it a full-time firefighter regularly assigned to hazardous duty? If that's the case, then the local board must accept this person's membership. The only thing that they're allowed to do is to notate, okay, well, based upon the pre-existing condition medical evaluation for pension purposes, they're notating this particular condition, they're notating this particular condition. So whether or not that ultimately results in an individual receiving a disability pension in the future, it may, but again, the local board has no authority under statutes to direct whether or not an employer is hiring someone. All that they have the authority to do is determine whether that position meets the criteria for statute for membership, and then notating any pre-existing conditions. I hope that answers that question.
So in other words, it's kind of like what we're talking about. You go ahead and put that information in the minutes, and you move forward and send them a letter. Notify them, okay?
I just wanted to chat a little bit about this, but the elected police and fire board came to the conclusion last week, or found out last week, that for police members, their membership doesn't start until after they finish the academy, which is 4 months. But the fire board members are voted in as members immediately upon hire, so there's kind of a 4-month disparity between our police and fire. We're kind of scratching our heads as to why that. I knew that, but I didn't know why exactly that happened without going back in years and years of records. But Robert reported that it was really a board decision.
Board decision, yeah.
And I guess from that answer that if our police board wanted to change streams and in effect membership from the date of hire, they would need to agendize that.
Yeah, because there were some boards that said we don't want to hire them until after the academy because there were too many getting hurt in the academy.
Right.
That was one of the reasons I've heard before. Does that make sense?
Yeah.
So, and then all of a sudden you've got a disability application. Well, the guy's hired on for 2 months in the academy. So some boards do it before, boards do it after, but it is a board decision for the police.
Do prescription glasses need to be noted as pre-existing, or?
Prescription glasses, I would say so. Because if the guy can't see, I mean, it depends on how bad it is. I mean, is he got Coke bottle glasses, or is anything you think that would prevent him from doing his duty as a police or firefighter, you'd want to notate. You're the board, you can make that decision. But I can't imagine anybody applying for disability because his glasses got too thick or something. I don't know. Did you have a comment? Or?
No.
Okay.
I was just wanting to just to reiterate. Again, the pre-existing condition notification. You're not saying you're precluding them from ever getting a disability. You're just putting them on notice that it could come into effect in the future. So if you wanted to list, every single thing that was on that report as a pre-existing condition, that's the authority of the local board. But that does not mean that they potentially won't get a disability in the future. It's just putting them on notice. So I would. Again, just really be cognizant of what the condition is in relationship to the duties that the person's doing.
Good question. Thank you. Okay, so in the case of a sudden death in my department, as a board secretary, how do I help the family get started for the benefits, or does the family have to initiate the benefit process? Okay, if there's a sudden death and it's killed in the line of duty, you'd sit down as a local board secretary and meet with the family and gather this information for the spreadsheet we just talked about, and then help them through the process. So, yes, you bring the family in and make sure they qualify for the benefits, and fill out the spreadsheet, because there's a portion on the spreadsheet on the radio button that you just change, and it will help you calculate it for them. Make sense? Okay. So, yes, you would want to help initiate that. Is there an option for a refund process in the table of contents that you can go over? Yes, if a person wants to get a refund, there are certain forms that you can actually fill out for that individual, and you'd send them to our office, and we would make the payment for that individual for the refund. It's simply signing off that they are taking their money out, and want it distributed to a certain location. And the local board secretary or the payroll group can help them with that. But it should be in the minutes of the meeting that this person's terminated and desiring a refund at that time. Because we shouldn't pay anything out from our office unless it's in the minutes of the meeting. Okay? Can you do a drop calculation using the spreadsheet? Yes, on the website we have one for the normal retirement, and we also on the website have one for the drop retirement. So if you go to public safety and you go down to the spreadsheet area, down at the bottom, see where it says spreadsheets. The first one is retirement forms, the second one is for the drop, the third one. So there's retirement forms for those that are hired before a certain date, after a certain date, but the drop spreadsheet will help you calculate the guy's drop paperwork that's needed. Can board members sign up for the local board portal? No. In other words, if you're an elected official or somebody elected through secret ballot, board members do not have access to the local board portal. That all has to be run through one person, the local board secretary, or her assistant if you designate one other person, because there has to be some security for that. Okay? I have a hard time choosing the start and end dates for the high 3-year estimate. I think you're like every other board secretary. That's exactly right. It's hard to find that high 3-year estimate, but if you use the local board portal, it finds it for you. It knows what date to start and what day to end. So if you're having a hard time choosing the start and end date, use the local board portal and help you calculate it and find as far as our records are concerned. But it gives you right there the data that you need. If the employer high 3 years is a little off, does it need to be changed to the high 3 years by PSPRS? I would say yes in that situation, unless you have records that show that it shouldn't be that. In other words, we have just the data, it's crunching it, and that's what we have. Maybe there was a payroll record that was off, and we wouldn't know that unless you provided information otherwise. So normally you'd want to go to the highest dollar amount for the employee who's retiring based off the contributions they've submitted through your payroll records, and then compare that to the local board portal. That's the best way to do it. So yes, you'd want to have the high 3 years, because otherwise the guy could say, hey, you didn't give me the high 3 years. But I like your idea of having the member bring in what he thinks is the high 3 years from the members only website, and then you got a basis to start with. Okay, will there ever be a time when survivors will never get any benefits after the member's death? The way the law reads right now in statute, that's not possible. They will always get 80% of the member's benefit, and that's just the way the law reads right now. So that's not possible unless the law changes. But they have to be married for 2 years. There's some qualifications on that as well. What if the member isn't married but has dependent children? If the member isn't married, the spouse wouldn't be listed as a designated beneficiary, but you'd put it on the spreadsheet as additional designated beneficiaries. But and you want to make sure those dependent children are listed, because they may be entitled to some type of benefit down the road. But you'd have to have proof of not only the paperwork, but also the member's name would have to be on the birth certificate, and there'd have to be some verifications for all that process to happen. There's a lot of supporting paperwork that has to come in when somebody retires. Their birth certificate. How many of you have ever sent in a marriage license for somebody that's been married to verify that it's been 2 years? Well, we don't accept marriage license anymore. We just accept marriage certificates, because it has to be registered with the county or the state. Okay? We've had too many guys say, yeah, I got married. Here's my license. They went up to Vegas. Well, they really didn't go to Vegas or something like that. All right, let's go back to the couple of questions then. Can we send the retirement estimates that we come up with the PSPRS staff confirmation before the member retires? The answer to that question is absolutely yes. Those can be sent in until you get comfortable with this, but I can tell you it's going to be exactly what's out of the database, the public safety portal that we have set up for the local boards. So the benefit staff is always welcome to work with you, Bonnie, Joanne, or Tara, or the group that's up here. They can always confirm that with you before the guy retires. It's probably a good idea. If you're new and you're not sure what to do, it's good to have them check it. But they'll ask you one question first, and what do you think that question is going to be? Have you been to the local board portal to verify the information? If you've answered that question, it's probably going to be accurate. Okay? After a refund package is completed, will the employee only receive his portion, or both the employee and the employee? It should be employer and employee's portion. Okay. Just want to make sure I got the question right. After the refund package is calculated, our active member services group does pay out both the employee and the employer portion. So the answer to that question is both in that situation, if they qualify for it. And it's kind of on a sliding scale of if the person's worked 5 years, then they'll get a certain amount, and after 5 years it's a percentage of the employer contributions. The law reads that if they've worked 10 years, they'll get all the employee money and 100% of the employer money that matches what the employees put in. That's for anybody that's hired before 1/1/2012. Anybody hired after that, it's a different calculation. If PSPRS finds an error in the retirement paperwork that would change the retirement amount, will the board need to meet again to approve the new retirement amount? The answer to that question is yes. It can be ratified in the next meeting, but it definitely needs to be the amount that's listed in the minutes of the meeting should be submitted, because we actually have people that look at the minutes to compare it to what's being paid to the individual. So yes, it needs to be verified and ratified by the board, because we really, again, goes back to that statement before, you really should not pay a benefit here at Public Safety unless the board's approved it. And it should be notated in the minutes of the meeting. So regarding the questions on the deceased member, if the member was retired at the time of death, would the beneficiary still be entitled to any benefits? The answer to that question is if he's used up all the contributions, the answer is it depends. They may or may not have any additional money paid out to the beneficiaries at that time. So that's kind of a depends question. How long has the guy been retired? Has he used all of his contributions up? If he has and there's no surviving spouse, the dependents would have to be under the age of 18. There may be a benefit available to them. Up to age 23, there may be a benefit if they're in college. But if they're over 23, probably there wouldn't be any beneficiary in this situation, the way the law reads. But it's a case-by-case basis. But if a person was active and dies, it's a whole different process that you'd go through to make that payment to the designated beneficiary at that time, especially if they weren't married. It looks like we'd like to go over some of the forms that are needed to include in the agenda packet for the local board members to review their packets for consideration of their meeting. Okay, that's a great question. Do the board members need to have everything in the packet in front of them to make a decision? Not necessarily. They don't need to know the tax forms. They don't need to know. They just need to know the packet is complete. Usually the Form 12 is the important one, because that talks about what the member is going to get. Some boards include the Form 12 in the packet so the members that are voting on it know what it is if they need to review it. But each board can set their own policy and their own procedure in that situation. Do they need to see the bank's information on Form 13? No. So it's case by case for each board. A lot of board members like to see the Form 11 and the Form 12 because that's how it's calculated, and the Form 12 tells you the actual benefit amount. But it's not necessary to put that in the packet as long as they know it was calculated correctly and it's been voted on by the board members. Now, let's go back. Well, the previous question is, that's all the board members need to see, but what do you send into our office is a complete packet. And the packet needs to be reviewed, see if it's signed, if it has the last pay period, the date of the board members that met. All of that has to be included in the packet, and before you send it off in one piece. Okay, what about prior years of service with different agencies? Can PSPRS confirm dates so we don't have to go off the employee says filling out the spreadsheet? That's a great question, too. You can actually contact our active members department, and they can look it up in the database for you, and they can provide actual dates of service for a prior employee. So yes, that can all be provided from our office. The person that's applying for that transfer for prior years with different agency does need to come up with a date range, and you'd need the Social Security number and things like that. But our active members group can actually look that up for you and confirm it for you. That's one service they do provide. Now, if they've already transferred that time, where's that time going to be at? In the local board portal under prior service. Okay, so you don't need to call if you know it's already been on the books. Does that make sense? That's a good question. I didn't think about the flip side of that. It's actually in the database already if it's already been transferred. Since we are completing the retirement input sheet well in advance of the retirement date, how do we determine the final contribution amount that's needed for the input sheet because the employee has variable hours? If we don't know the hours the employee will work and a future pay date, what should we put in that field? You should have the retirement paperwork pretty close to knowing what it might be, and you'd put in what you think that estimate will be, because we have to compare it to the final contribution. Now, if it's you put in there at $10 because you don't know what it is, and $150 comes in, then we have an issue with that. But you really need to have what you think the last pay period is going to be, or pretty close to what it might be in a final contribution. Okay? Because our office likes to look at, was a payment made on the 30th, and if so, was it $156 in our example, and we can verify that and kind of move on. But if you put nothing in there, then we don't know what it is or what the estimate should be. But we do like to get as close to what the actual pay period ending amount will be. Usually we have a meeting after the paperwork has been submitted, but the paperwork requires a meeting date. Is this just something we submit or amend later? Or should we be in the meeting and voting prior to submitting the paperwork? It's the second of the two. You should have the paperwork available at the meeting. The meeting should transpire, and then you put that date in and then send it in as if it had already been voted on. That's the best policy to follow. Make sense? Because otherwise you're saying, oh, this is a future amount. Well, you don't know what that future amount is. You don't know what the date is. Maybe you didn't even have a quorum for the meeting, so you shouldn't make the payment if that's the case. So you should be able to schedule your meetings around those types of things. Okay, which specific documents need to be sent via certified mail to PSPRS, or all of them? The law actually states that all documents sent into PSPRS for retirement paperwork should be sent via certified mail. Now, obviously, sometimes the budget doesn't always, preclude that, but that's what the law provides, especially certified mail for those documents have anything to do with a disability retirement, because those are time sensitive for any rehearing or things like that. But the law does say all mail to PSPRS should be done through certified mail for those reasons alone. Who is responsible for filling out the form for the transfer of time between agency, the member or the local board secretary? Now, if they're doing a transfer of service, that's always done by the member with our office. Okay? In other words, our office needs to see the time before and the start and end dates, which we have in our database if they're coming from public safety, and then it's sent over to our active members department to calculate that, and that transfer of funds is then sent to the new person where they're transferring the time. Okay? That makes sense? Now, if it's a purchasing time, then it's a little bit different, because you may be purchasing military time. Our office can take care of that, as well as a transfer from ASRS. But the local board secretary normally doesn't get too involved in that, because you don't know what's being transferred in the dates, but we have all that here if it's in public safety or CORP. So the member is really responsible for filling out the forms and transferring the time, because our office can help them with that, the active members department. If an employee worked as a law enforcement officer and has money in the fund from previous employer and now is in CORP under current employer, can he or she transfer CORP to public safety as they're looking to retire? The answer to that question is absolutely yes. It's just a straight transfer from CORP to public safety, or public safety to CORP. You can transfer from both those agencies. Again, it may not be the exact service time that they would get, but the dollar amounts can be transferred over to cover some of that prior service. So again, you'd want to talk to LaDon Toger or anybody in Active Member Services to help you with that particular process. Can you review the local board makeup, who's appointed, who's elected, etc.? Absolutely, we can do that. If you're a state agency, normally you have 3 members that are appointed by the governor office, and then 2 elected from that membership. And that's how your board is set up, with a chairman from that group. If you're a city or town, usually the mayor is the chairman of the board, or he may designate somebody to be the chairman of the board. 2 members are appointed by that chair, and they're usually from the community within that group. And there's also 2 elected memberships, 2 individuals that were elected from the membership by secret ballot. So you always have 2 contributing members on the board no matter what. If you're a fire district, it's a little bit different. Again, you have 2 elected from the secret ballot. The chairman is going to be probably the local board, the fire district clerk or secretary would serve as the chairman of that board, and then they would then appoint 2 members of the community. So it really is made up of always 5 members of the board, but most of the groups here are set up through the mayor as the chairperson. Does the sheriff appoint any members? No. If you're a county, it all comes from the county agency. In other words, the county would then, one of the county board of supervisors might be appointed to the board chairman, and then he would then appoint 2 individuals as well. But no, the sheriff would never appoint somebody to the board. Okay, is there a way of PSPRS to provide a list of all secretaries' contact information to share with each local board secretary only? It would be helpful in communicating such information, conducting surveys for police. Okay. Yes, we had a list at one time, and some of the board secretaries didn't want to be on the list. But if you're looking for certain boards, we can always provide that group for you. We do have all the agencies listed on the website, and you can click on that and usually find the agency that's involved with public safety. We have pretty close to 260 different local boards, and that kind of secretaries change about every sometimes year, or every 6 months, or every 3 years. So the list is ever changing in that situation. Okay, I see where the question's going also. It'd be helpful to communicate in conducting a survey of who determines how many do before the academy and those who enroll after into the PSPRS. There's no hard statistic on that rule because, as you mentioned earlier from Scottsdale, boards can change that, but they have to be consistent after they change it. But I would say most of the boards have them start at the beginning of the academy, and there are some boards that have elected not to do that. So hopefully that answers your question, because it's a board decision. Do you want to assume the liability while they're in the academy, or do you want to wait until after they're out of the academy? Because there are injuries that happen during the academy time. That's just a fact of life. So, yeah, we don't provide an ever-changing local board secretary list for everybody, but you can contact certain agencies if you'd like to know which ones contributed before or after. The active members department would actually know that if you wanted to find out specifics about that. On keeping records, should prior secretaries be passing on previous files? How far back should they be kept? Yes, the secretary should always pass on the files, and it's a local board decision for retention purposes. Some keep them longer than others, but you should always keep the retirement paperwork and any active forms that come into the agency. If you want to see how far you should keep them back, state agencies have a certain time frame, but we don't dictate that here at PSPRS. You'd have to contact the state agency to find out if you're under their jurisdiction. Maybe the city has a certain amount of time. You'd have to talk to each attorney individually that you work with there. All right, good question, but the retention is always a big thing, but each agency has their own jurisdiction of how long they keep their records. All right, so just to kind of summarize some things that we've gone over today, we've gone over the local board portal. Hopefully every local board secretary signs up for that. We've talked about the members only site, which is a very good, useful tool as well. We've talked about receiving information off the spreadsheet that's filled out, because it's really easy to do the retirement paperwork if you have the static data, the compensation, the final annual payout for that individual. You do need to have the board name and the date in which they met, because that's important now before the payment is made. We've talked a lot about what the board secretary's duties are. We've gone through quite a few examples of questions and answers. If there's no other questions at this time, we appreciate you coming in today.